Hello, this is Alexander Cross, Criminal Defense here in the San Francisco Bay Area. If you'd like to learn more about criminal defense, be sure to subscribe to our channel, Law Offices of Cross and Associates. So we received an interesting inquiry here on our YouTube channel. This has to do with somebody who failed to appear in court. Failed to appear in court, Martinez. Criminal attorney, Martinez. Warrant, Martinez. Let's see here. I had an appointment in court for a domestic violence matter. I'm a truck driver, and I made a delivery to another state. The truck, however, was wrecked. I had to wait for it to be fixed. Therefore, I didn't go to court. Now, I don't know how to have a warrant. Well, assuming that this DUI case went to criminal court and not civil court, because civil would be different, but assuming that this case did get filed on, assuming that the DA's office did file on the charges, and you did not appear in court at your arraignment date, there is a very, very high probability that you do, in fact, have a warrant. It'd be a good idea to call the court. Don't go to the courthouse because they'll just grab you right there. It'd be a good idea to call the court to see if the matter was heard and if a warrant got issued, a bench warrant. If it did, you have a couple of options. One is you can go to an attorney, and you probably should anyway so that you can have representation. You'll kill two birds with one stone this way. But the attorney could add the matter on calendar and talk to the judge to see if the judge is willing to recall the warrant without your physical presence. Now, usually for domestic violence cases, a judge will not recall a warrant without your physical presence because usually at the arraignment date, the judge will want to serve you with a criminal protective order to protect the victim. And he would want to serve you with that. But in some rare cases, the judge may be willing to temporarily recall the warrant so that you could come in at a later date, not too far out, so that the whole failure to appear can be addressed and so that the judge could personally serve you with the warrant and then continue with the case. The other thing that could happen is the judge could say no and he could set bail, and in which case you would just have to post the bail. Regardless, once the bail is posted or once the warrant issue is taken care of, that's when your attorney's going to have to enter pleas of not guilty. You're going to have to order copies, or the attorney's going to have to order copies of the police report and any other physical evidence that they might have. Then the judge would have to give a new court date to come back and start discussing the matter with the DA's office to resolve your case. Regardless, if you'd like to learn more about criminal defense here in the San Francisco Bay Area, be sure to subscribe to our channel, Law Offices of Cross and Associates. But if you've been accused of a crime and need representation, call us at 1-800-862-7677. Once again, 1-800-862-7677. On our next video, we're going to be discussing the case of somebody who was eavesdropping on calls from another person. Criminal attorney Martinez. Failed to appear in court, Martinez. Warrant, Martinez.